Second OVWIs or DUIs means mandatory jail time, and here's how it works. If you have been charged with a second OVWI in Indiana, even if your first case came from another state, if your second one occurred in the state of Indiana, Indiana law requires 5 actual days of jail. If it's a third offense, Indiana law requires 10 actual days of jail. And those are minimum sentences. So a lot of times people say, well, this happened 30 years ago. Does that still count against me? And the answer is yes. Now, there are different penalty ranges depending on how far in the past your prior was. If it was within the last 7 years, the new case will be charged as a level 6 felony. But even if it's beyond that, 10, 15, 20, 25, 30 years, Indiana law requires, and the court cannot accept any plea that doesn't have 5 days of jail on it. And again, that's 10 if you have 2 or more prior offenses. So we know nobody wants to go to jail. And part of our job is to mitigate that and reduce that as much as possible. But there is no way a prosecutor can offer or a court can accept a plea offer that doesn't have those mandatory jail days on it. There's some other penalty enhancements for a second OVWI offense. We're talking a 1-year mandatory license suspension. It's much more likely you will need an interlock device on your vehicle for specialized driving privileges. You run into the possibility of habitual offender enhancements, depending on how many prior convictions you had. And all of these are things that we need to talk about. So we want to know everything in your criminal history so that we can figure out a plan to reduce the risk to you so that we can keep your life as normal as possible. We know going in that the state is going to be asking for at least those 5 days, but there's all those other factors that play in as well. Issues that may come from the B&B, because as we get to the second, third, fourth, and beyond offense, the possible penalties go up tremendously. It's so important that we get out in front of this and figure out what we can do to mitigate those risks for you on a repeat OVWI offense. We're going to want to get involved with mitigation documents, everything we can get to really reduce that risk for you. So we're going to start with that process very early on. It's also important early on that we open up a line of communication with the prosecutor. If you are habitual eligible, we want to do everything we can to keep them from filing that enhancement while we work on the case. And so it's important that we started right away. If you have any questions about this, give us a call at 317-632-3642. Remember, always plead the fifth.